Hello students, put on your seatbelts because this lecture we're going to cover a heck of a lot of information. I try to keep these lectures about an hour because I know you have so much reading to do and so much studying, and you have 2 a week. So I'm going to try to hit the highlights this week, but there is a lot to cover. Let's first talk about the Uniform Commercial Code. Basically, the Uniform Commercial Code, a bunch of academics, lawyers, judges got together and said, among the 50 states in the United States, there were varying laws on I'm selling to this merchant, selling to this merchant, this company selling to this company. So why can't we come up with something that's uniform? So if I sell to California, I'm doing the same law, if you will, as if I'm selling into Arizona or vice versa. We need some sense of uniformity to know that how the transaction is going to be handled. So these academics, etc., came up with what's known as the Uniform Commercial Code. Now, all states in the U.S. have adopted, if not all, most of the Uniform Commercial Code as their state law. So this gives us uniformity when we're dealing with either customers or with other companies. Let's look at this video real quick that talks about the Uniform Commercial Code.
In this video, we will discuss the Uniform Commercial Code. Together with the common law, the Uniform Commercial Code is one of the primary sources of contract law in the U.S. The Uniform Commercial Code is commonly known as the UCC, and it's actually one of many model laws or uniform laws in the United States. Among other things, Article 2 of the UCC applies to transactions for the sale of goods. So the UCC itself is a model law, so it's not exactly the law. As a model law, it's really a proposal that each state has to choose whether to adopt or not. But the UCC was enormously successful. Pretty much every state has adopted the UCC. Remember, different states can have different laws, but because each state has practically the same version of the UCC, we can expect contract law for the sale of goods to be the same from state to state. That's why you'll see something called the New York Uniform Commercial Code, and you'll see something called the California Uniform Commercial Code. It's just each state's version of the Uniform Commercial Code. By and large, the California Uniform Commercial Code, the New York Uniform Commercial Code, and other states' uniform commercial codes will be the same. So if we have a contract for the sale of goods and parties from different states, they can be confident that the same law is going to apply. So for purposes of most contract law classes and for bar review classes generally, you should consider the UCC as the source of law governing transactions for the sale of goods, and the common law is probably going to govern everything else.
Okay, so in just a minute we'll go over what types of transactions the Uniform Commercial Code covers, but you need to be familiar with Uniform Commercial Code because when you're doing business, this is going to govern your transactions and you're going to have to follow it. So you might as well be on the front end of it so you don't have problems on the back end of the transaction. What's a commercial transaction? It's relatively ambiguous, believe it or not, but basically usually the sale of goods. It also covers leases, signing of the check, etc. We'll get into that. It does not apply to real property. That means houses, buildings, land, real property. Personal property, for example, in your house, the bookcase behind me is my personal property. My real property is the house in which that is. All right. As you'll see on your screen now, these are the various chapters, articles, divisions of what is covered within the Uniform Commercial Code. So let's first talk about sales. Now, when you're selling to your customer, how are you sure that you're going to get paid? Well, just think about going to Target. Target usually doesn't allow you to just go in and say, hey, I'll pay you in 90 days. You usually go in and pay with cash or pay with a credit card. So that's known as a payment in advance. That's safest for the seller and riskiest for you, the buyer, until you get your goods. At Target, it doesn't matter. But if you're buying something from someone other than Amazon, for example, you're undertaking some level of risk that you're not going to get it. You've sent the money, but you may not get it. So that's riskier for you as the buyer. Now on this page, you'll see this is going from safest to the seller to safest to the buyer. Letters of credit, we're going to talk about them in a little while. Documentary drafts, we talk about them in another lecture. Open account, that's the best for you because you buy something and say, I'll just pay for it later. What is a letter of credit? Now, we may have discussed this in another lecture, but just in case we haven't, we've got a lot of lectures and I'm recording these out of order. So if we already have, I apologize. But essentially, think back about if any of you saw 1970s movies where the drug dealers are in the, pardon the example, but the drug dealers are in the alley in the movie, and the guy has a briefcase full of whatever drug and the other guy has a briefcase full of money, and they say, wait a minute, I'm not going to hand over the drugs until you hand over the money. Well, and then there's a third guy there and they say, we'll hand them to that guy. He'll hold both of them and then hand them over. That's sort of the way to think about a letter of credit. You're a seller. You're selling something to someone in, let's just say, Singapore. First time you've had this customer, you don't know if they're really going to pay. So you don't want to hand over what you've just manufactured that you're trying to sell until you know you're going to get paid. But at the same time, your customer in Singapore, they don't want to hand you over the money. It's the first time they purchase from you until they know they're going to get the goods. So like the guy the stranger standing in the aisle that gets both of the briefcases, banks get involved in your sales transaction. The customer, who is the buyer, goes to the customer's bank. You see, that's called the issuing bank, and says, hey, I need you to give a letter of credit that guarantees I'm going to pay for this. Okay? Then that bank will send the letter of credit to your bank, the guy that is selling, the seller, saying, hey, as soon as we get such and such documents, you get paid automatically. Now, the bank has to pay you if you provide such and such documents to the seller. There's no way out. It's guaranteed. It is a letter of credit. So what documents? Well, traditionally they're what's known as documents of title and documents of shipping. So you as the seller, now we've got this letter of credit all issued, but you don't get paid until you can deliver such and such documents to the buyer. And he needs documents to be able to pick up to prove he's the owner when these things land in his port in Singapore. You know, the boat pulls in, the ship pulls in Singapore. So you effectively put your items that you're selling onto a boat in Houston or Ship Channel in, Catoosa by Tulsa. But anyway, you put it on for international shipment. Then the boat captain will give you what's known as a bill of lading. And that basically says, hey, I got the stuff. It's on my ship. Then you take the bill of lading and you send it to the seller, or more likely the seller's bank, and saying, here it is. I gave him the bill of lading. Then his bank, the customer bank, has to pay the letter of credit. You see how it's similar to the drug deal? Nobody got the money, nobody got the goods until we were assured that each was going the other way. That's a real simplification of a letter of credit transaction. The banks aren't involved in the purchase and sale, but the banks are involved by guaranteeing that payment is made. Here's another way to look at it. I'll let you read through that on your own. And again, I'll be happy to go through this if somebody requests a review period before a test, one of our tests. to go this, but this sort of is a diagram of how it works. Who does what on the letter of credit transaction. Now, another thing covered by Uniform Commercial Code is bulk sales. Now, I just say this real quickly because you're very unlikely to ever have this, but let's say your business goes out, you're going out of business or something. Well, you may have a lot of creditors. You start your own business, you have a lot of creditors, and it doesn't go well, and you might have to go out of business. Well, you say, I've got to sell all my inventory. That's known as a bulk sale. Well, there are laws under the Uniform Commercial Code that you have to notify your creditors, those people to whom you owe money, maybe the utility to whom you got to pay a light bill, maybe your suppliers that gave you the component parts to make your goods. You have to notify them if you're about to sell everything because they're also creditors and they may have a claim against them. Or that somebody, some dishonest business owner doesn't sell everything in his business to his brother-in-law for $1. It avoids a sweetheart deal. So that's bulk sales. Those are covered under Uniform Commercial Code. Also covered are warehouse receipts, bills of lading, and documents of title. We already talked about bill of lading. I'll ask you to watch this YouTube. Well, let's pop on this YouTube real quick. This is the document that the ship captain keep in mind, can give you to show, hey, your customer can pick this up when I deliver it in the ship. It's a document that's showing title, just like your car title. When you buy a car, let's say that you owe money to the bank. Well, you're actually going to have a lien and a car title, and it'll show Bank of Oklahoma has rights in this car until they pay it off. Well, when Bank of Oklahoma, you pay off your car loan, it's you. You're clear on the title, and then when you sell your car, you have to take your car title and you sign it, and the buyer signs it. That's a document of title. So let's look at this bill of lading YouTube real quick.
Through my online store alone, we've sold over $500,000 worth of spices. That's so great.
Sorry about the ads. It's the state of YouTube. All right, now don't be stressed out about a bunch of new terms that were thrown at you. You don't necessarily need to know them for any test. But if you happen to be involved in international sales in your company, a very likely event because no company truly is just domestic anymore. We're all international companies. You'll, over the course of either that or maybe international business course, you'll learn some of these things. To me, the most important thing is the concept of letter of credit that sometimes guarantees payment, and what a bill of lading is, and that bill of lading, warehouse receipts. Hey, I put something in my warehouse and you gave me a receipt. These are all documents of title, and the Uniform Commercial Code could cover it. Now, UCC also can cover certain parts of securities. Maybe some of you have Robinhood, and so you're investing in stocks, or you're on Charles Schwab or whatever, and you invest in stocks. Well, someone holds literally a piece of paper, digital or otherwise, that shows you own a piece of the company. That's known as a security or an investment security, depend on how you want to do it. There are also bank notes, T-bills, basically says the government owes you money, bonds, etc. Well, Article 8, in addition, Article 8 deals with secured loans, secured transactions, or secured loans. So, sorry, that's a new topic. We've moved off securities. Let's move on to secured transactions. And again, to a certain extent, that's beyond the scope of this class, but we're going to touch on what a secure transaction is. And then soon we're going to come back to just sale of goods on the UCC, because that is our main focus in this class. Secure transaction. Well, let's think about not an international shipment, but you are going to go buy a car and you don't have all the money. Okay, you're going to go get you a new BMW while you're a college student. Probably not a good idea because of the expense, but you're going to get a brand new BMW. You don't have all the money. So you go to BMW and they say, we'll take how much down, but we're going to lend you the remainder through BMW Credit Corp, their finance arm. Well, in order to show that you don't own the car outright, on the title, BMW Finance will say, we have a lien, we have a security interest in the car that student is driving. It's not his or hers completely. We also own it, or we have a right or a claim known as a lien or a security interest against the car. So you're the debtor. The collateral down here at the bottom of that is the car. You're going to sign a promissory note and what's known as a security agreement. And then the creditor will probably file something to show that you owe the money. Now, again, Article 9 is beyond the scope of this class, but for example, if a house, if you have a mortgage, let's say the bank lent you money, the bank will register in public records. So you can go down, if you happen to live in Tulsa County, you can go down to Tulsa County Courthouse and look up by your property address and find that what bank has an interest in your property. That's a secured transaction. In consideration for receiving money from the bank to purchase your property, your house, you've given a security interest to the bank. The promissory note says, yeah, I got to pay you, but they'll make you sign a second document that says, I'm giving you a security interest. You have a secured interest in my property. Okay, so that's what secured transactions are. It just makes sure that creditors put the world on notice. Hey, you can't go seize this house. You can't seize this car, whatever. We have first rights because we lent the money for that, and you're on notice because it's publicly filed, or it's on the car title, for example. Now, we basically covered all those things about the areas that UCC covers, and you've just got to highlight about what many of those are. Now let's come back to Article 2 of the Uniform Commercial Code. And really, the majority of what we want to talk about today is the sale of goods, because that's what most of you will be involved in. Now, sale of services are a little different. Put your sale of goods hats on. That's what we're talking about. So basically, Article 2 of the Uniform Commercial Code, or in Oklahoma, the Oklahoma Uniform Commercial Code, will talk about the sale of tangible goods and the duties. There's also a 2A, by the way, that refers to lease contracts. So if you're renting, you have a question, you can look up Article 2A of the Uniform Commercial Code. Now let's go back to Article 2, sale of goods. The Uniform Commercial Code applies. However, if you and I agree, you're renting from, you're buying something from me, and we agree, well, the UCC won't apply in such and such respect, we have a freedom of contract. So we can alter that so that the court would look at the contract to see what rules rather than the Uniform Commercial Code. If that issue is not in the contract, the court's going to go to the Uniform Commercial Code. And most contracts will incorporate many of the same principles as the Uniform Commercial Code. Okay. I'll see conflicts of law what a judge will look at if he's not sure which law to apply. I already talked about Article 2 is sale of goods, not property, not real estate, not services, and not intangible property, intellectual property, patents, trademarks, etc. A sale, real simple. Sale means I pass title. What are goods? I'll let you look at this. This is a definition of goods. Why are we looking at definitions so much? Well, if the law says ABC, you can either win or lose a case based on, do the facts meet A, B, or C? If you try to sue me under the UCC for my services I provided, the judge is going to throw it out and laugh and say the UCC has nothing to do with services. It only has to do with goods. What are goods? Now, if there are goods and services combined, I sell you a sprinkler system, but with it also a warranty and for 2 years, and I'm going to show you how to use this automated sprinkler system for 2 years. That's a mixed contract. And so the UCC could apply for that as well, even though it's two things, goods and services. When it's combined and primarily it's a sale of goods, the court will say, yeah, it's really a Uniform Commercial Code issue because it's primarily the sale of goods. I'll let you look at that. Now, the UCC and much of our law, from federal consumer law to state laws, will basically give 2 levels of protection. We have this, when you and I are both business owners, okay, student, you own such and such business, I own such and such business, and we're buying and selling, we're considered to be sophisticated and on an even level. However, under various laws, including Uniform Commercial Code, if I'm the business that is selling and you're a consumer, that is, you're buying something for household use, personal use, you're not buying it for your company, you're not buying it for resale, but I sell you a computer for your home use. Well, then I'm a merchant and you're a consumer. See my hands here? I actually have higher duties towards you if you are a consumer than if we were both merchants. Okay, so you got that concept. I'll let you read through who's a merchant, what's the definition. Okay, we're going to keep going. Now, in another lecture, we talk about the common law, case law. When is a contract formed? Offer, acceptance, payment or consideration, it's legal. Well, under the Uniform Commercial Code, we're also forming contracts, aren't we? Because we're offering to sell goods and we're accepting the sale of goods and we're paying for them. So in contract law, I just say, hey, I offer this and you accept it, we have a contract. However, under the UCC, we're dealing with merchants. 2 businesses is the best way to think about it. And you might be buying hundreds and hundreds or thousands of components to build computers, for example. Well, if you issue a PO and say, hey, I need so many this coming year, and I guarantee that I'll buy 100,000 units motherboards to go in my computer this year, but I'll give you a call-off purchase order. I'll let you know when to ship them based on my demand. You kind of don't know when you're supposed to perform, but you do know it's sometime during the 12 months. Well, the UCC says, even though you don't know exactly when the contract's to be performed, it can still be considered a contract. Again, the UCC is intended for uniformity and ease of understanding, so merchants can relax and know, if I'm selling, here's the set of rules. Same thing for a buyer. I'll let you look at indefiniteness, whether there really was an offer and acceptance, open terms. I'll let you look at that. Let's look at firm offer. When is something a firm offer? I mean, here's a good question. Let's say that you look in the Tulsa World newspaper online, and you see, Jim Norton Toyota is selling brand new 4Runners for $5,000. Okay? And you rush in there. Heck yes, I'm going to buy one for $5,000, knowing that the newspaper has made an error and it really is $50,000, not $5,000. Has that merchant, Jim Norton Toyota, is that a firm offer? Okay? Well, not necessarily. It's a firm offer or a legitimate offer when the company selling, merchant offeror, gives assurances in a signed writing, that can be digital, that you have the offer, it's irrevocable. In other words, you can't pull it back for a certain period of time, and it's certain, etc. That's a firm offer. Now keep in mind, sometimes you're going to want to pull back. You're the buyer for your company and you bought these 100,000 motherboards, but then next week you found out somebody in Taiwan that'll sell them for half, and you get your bonus is based on profitability. You're going to make another $100,000 as an MBA your first year if you can cancel the first one and go to the second one, second supplier. Well, have you given a firm offer? These are some of the things you look at. In other words, can you back out of your first offer to purchase? And these are some of the factors you look at to determine whether you could back out or not, or you're stuck because you made an offer. When did they accept? When did the supplier, that might be another thing, goes, hey, wait a minute. I did offer this U.S. company to buy from them, but then I find out that I could buy for half as much from a Taiwanese company. Did they accept the goods? Can I pull back my offer because they haven't accepted yet? Well, when does an acceptance happen? They can make the acceptance in, quote, any reasonable manner and by any reasonable means. All right? Promise to ship, etc. We'll send that. So if vendor number one, let's do two scenarios. Vendor number one says, yep, we'll ship them. We got them. Here's an acknowledgement. You probably have a contract. However, if the shipper number one in the U.S. says, well, yeah, you've offered to buy 100,000 for X dollars, but we're not going to give you the A quality. We've got the B quality for that price. They haven't accepted your offer, have they? It was a qualified acceptance, so it's technically not a firm acceptance, if you will. And theoretically, you might be able to get out of that and go to the second supplier. Now, how about communicating the acceptance? Let's say he mailed you an acceptance. Well, and then the next day you withdrew your offer to buy from them, and then the next day you get the mail saying we accept. Did acceptance happen when he put it in the mailbox? Well, under the UCC, if you're the buyer, if you're not notified, and I'm quoting here, in a reasonable time that they've accepted by starting performance or written acceptance, then you can pull back your offer, right? So if you're a seller, let's now flip hats. You're the U.S. seller of these components for computers. Don't you think it would make sense to accept pretty quickly your customer orders, maybe within 24, 48 hours after your technical side and your sales side and your finance side have all confirmed that that's consistent with our sale and our pricing, etc. You might want to get your acceptance out there. How do you do it? Well, any of you who have worked in business on buying and selling know this is usually how it goes, okay? The first figure is the seller. These are the guys that want to sell you the components for computers. Now, we're going on a new term. You say, I want A grade motherboards, components, and to be shipped at B time and at C price. Okay? So that's I beg your pardon. The seller gives you the quote. You've asked for a quote, the seller gives you the quote. So you're like, okay, that works. You send back a purchase order, but your purchase order says, I want A grade at B price, same price, but I don't want them for 2 years. All right? Well, one of the conditions has changed, and so you, as the buyer, haven't accepted exactly what the offer to sell was, have you? It's different. So the seller then issues their acknowledgement. Hey, got your order. And by the way, the terms are ABC, what they originally quoted. And then they issue their invoice. And the invoice says, hey, it's ABC. Well, are you stuck? Well, let's look at how the UCC covers that. If you're selling to a consumer, or in other words, if only one of you two, buyer and seller, is a merchant, then we go back to the original terms of the offer. So it would probably be the quote. Or if the offer is considered the purchase order, we would go back to the purchase order. And that's the most likely in most transactions. Now, this is so confusing. 2207. Basic Uniform Commercial Code says every day purchase orders come out, sales order acknowledgments come out. They have different, on page 2 of those documents, they have the traditional terms and conditions for that company, and the invoice has different terms. So each buyer and seller have different terms and conditions. And the UCC says, well, we can't just set aside every transaction because the fine print is different. What do we do? So the UCC says, keep in mind, you sent your PO and you sent your purchase order, and your supplier comes back with acknowledgement, says, we've got some additional or differing forms, but we're acknowledging it. Well, under the UCC, the seller's additional, not different or conflicting terms, are automatically part of the contract. Okay? Unless your offer, purchase order, said you can't change any terms. Most purchase orders do with sophisticated companies. It materially, the new parts from your supplier, the new provisions, really materially change the contract. For example, price, quality, quantity, timing, any of those would be serious enough a change that it's not just an additional term, it's conflicting, it's different. So we're just talking about additional terms. Then it would go back to the original PO. Or 3, you get their sales order acknowledgement, you're surprised, say, wait. I didn't agree to those. We're going back to my PO, okay? In each of those instances, which terms apply? Your purchase order, offer to purchase, or the sales order acknowledgement, the acceptance, and then we're going to sell it to you. Nope, we would go back to the purchase order terms, okay? Now, you have to read through this a few times in probably the textbook because it's a complicated concept. Now, I'm going to let you read through 2207, and we're going to there's a couple of YouTubes that go through it fairly well. So let's look at those and see if that if they do a good job explaining this.
There's no shortage of advice on how to become a better manager. In fact, there are millions of pieces of advice.
In this video, we will introduce how the Uniform Commercial Code modifies the Common Law Mirror Image Rule. The Common Law Mirror Image Rule tells us that to have a contract, the offer and the acceptance must be the same. If the acceptance doesn't mirror the offer, we don't have a contract. Under the UCC, a different set of rules apply. So let's say a farmer sends an offer to a businessman to sell some apples. And he's offering 100 apples for $100. Payment has to be made by May 1st at 10 a.m. and delivery is by truck. And our businessman says, sure, 100 apples for $100, payment on May 1st by 10 a.m., and sure, delivery by truck. And also the industry standard return policy that we have 2 days to return the apples if we're not satisfied. The businessman's acceptance didn't precisely mirror the farmer's offer because the businessman added an additional term. He has 2 days to return the apples if he's not satisfied. Under the common law, we might not have a contract for apples because the acceptance didn't mirror the offer. The UCC, though, gives us different rules. First, we have to ask, are the parties merchants or not? And merchants means, in this case, that both parties are in the business of buying and selling fruit or buying and selling apples. And the UCC tells us that additional terms in an acceptance between merchants become part of the contract, unless the offer says that the offeree can't add terms, or if the additional terms materially change the contract, or if the offerer says, no, I don't accept the additional terms. Well, here the businessman accepted all the major terms of the offer, but he added one additional term, a standard 2-day return policy, and that's probably not a material change to the offer. As a non-material additional term, it should become part of the contract. If the farmer doesn't object, the 2-day return option becomes part of the contract. So now, even though the acceptance didn't mirror the offer, we have a contract between merchants for 100 apples. If you'd like to discuss the UCC or any other matter related.
All right, I know that's very simple, but I like the way that if you're a visual learner, that's very helpful. Let's see if this YouTube video also helps.
In this video, we'll continue to look at how the Uniform Commercial Code, the UCC, modifies the mirror image rule. If you recall, in Part 1 we looked at additional terms, such as where a buyer orders 10 apples for $100 and the seller's acceptance says, sure, 10 apples, $100, and we'll be wrapping those apples in plastic. And we learned additional terms can become part of the contract unless they materially alter the contract, or if the offerer says you can't add any terms to this offer, or finally, if the offerer objects to the additional terms within a reasonable amount of time. But now let's say we have two merchants, and a buyer decides to order some tires. She orders 10 tires for $500, and she has a provision stating that any dispute must be litigated within 3 years. In other words, if a party discovered a problem in connection with the contract in 2015, she would have until 2018 to commence the lawsuit. And the seller states that he accepts the offer, but his acceptance form says, sure, 10 tires for $500, but any litigation must be brought within 1 year. So here we have different or contradicting terms. Under the traditional mirror image rule, because the seller's terms are different from the buyer's terms, we would not have a contract. But the UCC tells us that even if an acceptance doesn't match the offer, we can still have a contract. And there are three major approaches that courts take to to deal with contradictory or different terms in an acceptance. And the most common approach is called the knockout rule, which we'll be looking at in this video, and our two other approaches are the fallout rule and to treat the contradictory terms the same as additional terms. Under the knockout rule, the contradictory terms are going to knock each other out. They're going to be taken out of the contract. We have 10 tires for $500, but the contradictory terms should be eliminated under the knockout rule. Now our contract has the terms that the parties agreed on, 10 tires for $500. So far, so good. But how long do parties have to commence a lawsuit? Remember, the court just knocked those contradictory terms out of the contract. The answer is that the Uniform Commercial Code, that statute, will provide us with the missing terms. In this case, the UCC would probably tell us that the parties should have 4 years to commence a litigation. So if there's a problem in connection with the contract that's discovered in 2015, parties will have until 2019 to commence a litigation. If you have any questions about the UCC or any other matter.
Okay, so that way you saw that this section 2207 of the Uniform Commercial Code basically addresses two issues. If the the acceptance has an additional term in addition to what the offer has, you saw how it's handled. If the acceptance has a differing or conflicting term, what happens? Knockout rule, for example. Okay, let's move on. I'll let you read through these. These are just some of when there's some vagaries or the judge has to look maybe outside the contract to determine, gee, who wins, buyer or seller. He's going to look at what have they done over the years? How have they acted over the years? You know, have they officially accepted or accepted by their conduct, for example? Now, let's talk about, again, we're talking about legal contract issues under the Uniform Commercial Code. So we're selling goods. Well, somebody might come to you and say, hey, we had a deal. Well, the Uniform Commercial Code envisions that there are many transactions that are of significance, that there has to be some kind of writing. You just can't say, hey, we had a handshake deal, et cetera, et cetera. When you're selling goods, the Uniform Commercial Code has what they call the Statute of Frauds. I don't like that terminology, but it's been that way, ever since there's been UCC and before. And basically it says certain contracts, in order to be enforceable, must be in writing. In other words, you wouldn't be able to go to court and say, hey, we had a contract, unless it was in writing for these type of contracts. Sale of goods at $500 or more. Lease contracts requiring you to pay more than $1,000. Those must be in writing to be enforceable under the Uniform Commercial Code. Okay, so be wary if they're not in writing. You'll see what kind of writing. Well, it can be digital, it can be hard copy, and the substance of the communication, it has to be fairly clear that it shows there's an intent for us as buyer and seller to form a contract. Okay, and both parties have to show it. I mean, I can't say, hey, my wife agrees to buy your car. That's not really a contract. You need my wife to say, yeah, I'm buying your car, and then put something in writing. Okay. I'll let you read through this. Now, the Uniform Commercial Code has set this rule, the Statute of Fraud, saying, hey, some things have to be in writing. Well, I hate to say this, but so many laws have exceptions to themselves, and this is one of them. The UCC, Uniform Commercial Code, defines 3 scenarios in which it doesn't have to be in writing. Specially manufactured goods. Why would they do that, the Uniform Commercial Code? Well, if I call you and say, I want 5,000 buttons that that say, oh, by the way, shout out to Hanshin Tigers, my favorite Japanese professional baseball league team. Sorry about the distracting t-shirt. I want 1,000 buttons that say, vote Kevin, president of the universe, okay? And you own a company that manufactures buttons, and you did it with my big face just smiling stupidly grinning stupidly on the button. Well, even though we don't have it in writing, even though it is for sale of goods for over $500, the Uniform Commercial Code says, well, we're not going to require you to put that one in writing because they're specially manufactured for me. It's not like you can turn around and sell them to anyone else. So that's an exception where that there's still a contract even though it's not in writing. Second, if I have made an admission, like I wrote an email, 3 months ago. Well, yeah, I promised to buy such and such. That's an admission by me. So even though we don't have a written contract, the court would say, wait a minute, I have something in writing or a recorded phone call or something where you admitted you had a contract. So it doesn't have to be in writing. And a third, partial performance. If we begin performing, I'm going to pay you $1,000 for these buttons. Well, you send me the first 100 and I pay $100. Well, we've done partial performance of that contract. So that's proof that we both intended to have a contract, even though it's not in writing. So that would be the third exception, or in other words, the third instance in which we don't have to have something in writing for the sale of goods over $500, and it's still enforceable. Now, when a judge is looking at things, and this is kind of important if you ever get to litigation, basically, most courts will just say, well, it's a contract dispute. Kevin agreed to order 100 buttons. There's a written contract. They did them, but there was some provision. I thought it had to be glossy buttons, and you gave them to me in matte finish or something like that. Let's say that. Well, let's say that that's not in the contract. A judge wants to look at the contract, and they call the four corners rule, look at the face of the contract, and if there's language in there that addresses glossy versus matte, he says, you win, sellers, because right here it said glossy or matte, whatever position you want to take. But if it's not there, then the judge has to look outside of the contract. He said, it's vague as to this issue. What is the finish on the button? So at that point, the judge is allowed to look outside of the four corners, and he might look at how we've dealt in the past. He might look at emails we've had. We might look at how we acted after the contract. So this is called the parole evidence. Again, I hate that terminology. Sounds like you just got out of jail. But it really means that the judge can look around and outside the contract for other evidence, which he wouldn't be allowed to if it were clear within the contract. And the judge, like we said, they'll look at things like course of dealing, what do people do in the industry, et cetera, et cetera. I'm going to let you read a lot of this. I like unconscionability because especially when you're a consumer, there's various laws that protect you. So as I'm talking as a student, I don't think this is on the test, but anyway, unconscionability is one of those defenses to a contract. So let's say that you sign a lease contract with student housing at NSU, but on page 3 of your lease agreement, it says, if you so much as ever track mud in, you owe us an additional 3 months rent after your lease is done. Well, that's known as unconscionability for a variety of reasons, but at least 2 reasons. Number one, talk about disparity of bargaining power. If you're trying to get housing with university, they have a form that says take it or leave it. You're going to live in our housing. Boom, this is it. So it's kind of unconscionable to enforce unfair terms. And the fact you'd have to pay money for just tracking mud in, that's not fair. So even under the Uniform Commercial Code, I was talking about the lease, but Uniform Commercial Code, there's this concept of if it's unconscionable, it's just not right. There's an equitable reason that just says, hold the phone. I'm not going to enforce that. That's actually a way to get out of a contract. All right, let's see. Now, contracts for the sale, international sale of goods, my professional specialty. There is an international equivalent, rough equivalent to the Uniform Commercial Code, and it's called the United Nations Convention on the Contracts for the International Sale of Goods. We just usually call it the CISG. And essentially, as you know, the Uniform Commercial Code is applying to sales within the U.S. What if you're selling to a customer outside of the U.S.? Okay, as many of us are, many of we are, pardon my poor grammar, then indeed, if they don't want to agree to, let's go back to Singapore, they don't want to agree that U.S. law applies. We don't want to agree that the Singapore law applies because we're strangers to Singaporean law and they're strangers to U.S. law. You can agree, and even if you don't agree, this law applies unless you have a contract that says it doesn't. By the way, most international purchase orders and most international invoices have a provision say the CISG does not apply. But if you don't have that in there, or you don't say what law applies, and if my country, seller, and the buyer's country, Singapore in this instance, are both signatories to the CISG, 84 largest industrialized nations in the world, then the CISG applies. So basically that's saying the International Uniform Commercial Code, if you will, the CISG applies to our sale. It goes to, just like UCC, it's not, unlike, I should say, the UCC, it's not consumer contracts. So this is different from UCC because it's just two companies selling to each other. It doesn't have to do with services, just like UCC. I'll let you look through the CISG, but I want to focus on, that aside, make sure that in your international contracts, in addition to, price, delivery, payment terms, those major things, your guarantee, your warranty. In addition, on your international contracts, make sure you always have 4 things in there. Number 1, you could have choice of language. In other words, you could say the English version of this applies. Pretty standard in many international contracts. Number 2, choice of forum and choice of law. Now, 2 different things. Let's say I'm selling to the Singaporean customer. As a U.S. supplier, I would hope to say U.S. law applies to this transaction. So U.S. law means U.S. substantive law. What does our law say about warranties? What does our law say about guarantees? What does our law say about offer and acceptance? That's the choice of law. But there's also choice of forum. If we have a dispute, where are we going to hear it? Okay? And if it's Singapore, they're not going to want to come to the U.S. and we're not going to want to go to Singapore. So in big contracts, sometimes I'll have a neutral forum. We might both go to London or might both go somewhere else, but we'll have a dispute resolution, either the courts or more often mediation or arbitration. But that's the forum where any disputes will be decided. And also make sure you have what's known as a force majeure clause. Just pick up any contract you've signed and for sale of goods, or if your company has, there'll be a force majeure clause in there that basically is a French way of saying if there are circumstances beyond our control, reasonable control, then that will excuse performance, either purchase or sale. A war, in World War II, I couldn't sell on to Germany. Well, that's beyond my control. So neither the buyer nor the seller would be liable for breaching that contract because a force majeure happened, hurricane, etc. Okay, let's talk about what happens under the Uniform Commercial Code if you breach my contract or I breach your contract. I don't perform, okay? Well, what do you have to do under the UCC? What are your obligations? Well, if a seller, I have to give you the goods that you ordered, conforming goods. They have to conform to what I represented and what you purchased, okay? I have to tender delivery. We should agree where the goods are going to be delivered. Now, if we don't specify it, then it can often be considered my place of business. I'm selling to you, or location of goods if we both know they're in Iowa. Okay, but usually it's really a good idea to define those terms in your contract, because shipping and insurance can be huge costs, as you know. So get them in writing. Now, Incoterms. This is an issue of who is responsible for shipping costs and for insurance costs. Now, most companies now are using Incoterms, and basically it's a chart of buyer responsibility, seller responsibility, based on these international sale rules. But even if it's a domestic purchase from California to Oklahoma, you can theoretically still use Incoterms, and most companies do. And it basically just says who has to pay for what. So Ex Works. Let's go to the very first column, if you will. You see any transit mode, and below that, top left, and that says EXW Ex Works. That means if you're the seller, I'm just going to package, and you're going to have to basically pick it up at my place. Now, however, if import duty, taxes, security clearance, as you can see on Ex Works, the buyer has to do almost everything except packaging. You're just moving down that column. So as a seller, I don't have to do hardly anything if our agreed sales term is Ex Works. Conversely, all the way to the right, if we agree to the delivery duty paid term, I, the seller, have to do everything. I've got to package it. I've got to load it up. I've got to put it on a ship. I've got to get it to you. I've got to pay customs. I've got to pay insurance all the way until you get it. So don't lose your job, and also conversely look great at your job when you understand that the sale price is not just the sale price of the goods. You darn well better get in writing who has responsibility for insurance, risk of loss, shipping, because that could eat up all your profit. I mean, let's say you sell $1 million good, but then you have $100,000 in shipping costs and you forgot, and so it's so vague that you get charged. You may lose your job over that because the company might lose money on it. So make sure you get this appropriate shipping term / Incoterm. Now, the UCC and others have domestic terms that you could use, but if you don't use Incoterms, you can literally put the term, we'll pick up at our dock, we'll do such and such, or we will pay transportation costs, we will pay insurance. So whether you use Incoterms or not, make sure the relative obligation from buyer and seller is in your written contract, which means your quote, your either your purchase order if you're buying, your sales order, acknowledgement, and invoice if you're selling. Okay, I'm trying to get you quickly through there. I'm a seller. What are my obligations as a seller? Well, I basically have to sell what I promised to sell you. And there's a touch of leeway, that they don't have to be perfect per se, but they pretty well have to conform, I should say, to what I promised that I would sell you and what your purchase order asked for. Okay, so that's my obligation. Now, if I fail in that, then my buyer, you can accept it, and probably what you do say, they sent us this and 10% are no good, so we'll pay you for the 90% that were good. But you could still accept the goods, and we'd probably work out that. If 10% were no good, 90% were good, you as a buyer often have the right to reject the entire shipment. Then I'd have to come and pick them up and bring them back, and etc. Now think about back on our when you found another supplier that could sell you these computer parts much lower and you look good to your boss. If I send you 10% that don't work, theoretically, now there's exceptions to every rule, but theoretically, you could reject them, send them back, and buy them from the lower supplier. Okay. Again, you could accept part and reject part. We talked about that. I'm now there's a right of cure sometimes, and I might have a reasonable period to fix what I sent you, but that's kind of fact specific. So for example, if I send you something for computers and you're not going to sell the computers for 3 more months, it might be reasonable for me to have 14 days to get you all conforming parts, 100% conforming. So that 10, I'll get them to you. However, if I'm selling you lettuce and you've got to put it in your grocery store tomorrow and it's brown, it's you don't have the time to let me send you new lettuce. You may have to go down the street and get some lettuce from the local people. So the right of cure is a little subjective. It depends on the facts of the case. In other words, the seller's right to come in and fix it. Cure. Excuse me. I'm going to let you go on some of the other things you can do if you don't deliver completely conforming goods. Let's see. And again, I'd like you to read through all this, but I'm trying to hit the highlights and keep it in a reasonable period of time. Now, as the buyer, obviously, you have the right of inspection to be able to look at them and see if they're conforming, and if they don't conform, if they're not what they were represented, if they're faulty, then you have various opportunities to send them back, demand that I replace new ones, etc. So you have that right. When does this inspection occur? Any reasonable time. How is acceptance? I'll let you read through that. Partial acceptance, again, I can accept some, but not all. But it's not like I can accept one tiny one, say, hey, come pick up 99% of them. There's a rule of reasonableness in this. Again, I want you to read through these, but I'm trying to hit the highlights for you. What happens when there is a breach? Okay, you sold me non-conforming goods, or I sold you non-conforming goods, or you didn't pay me. What happens? Well, if you already have the goods, or if I still have the goods, I'm sorry, I'm the seller, then you have the right to cancel the contract. Hey, you never sent them to me. Or if you said, I'm not going to pay you, then I have the right to cancel the contract and sell them to someone else. And this is how we do it. We have to, I have to notify you, and you still might owe me something, but not 100%. Now, if I still have them, I could withhold delivery because you've told me you're not going to pay me. Or if you've told me that you're insolvent, you're going bankrupt, I can keep the goods and not send them to you. Now, if you already have them, but they're non-conforming or they're defective, well, you have the right, theoretically, unless our contract says no, you have to send them back to me and I'll fix them, and I'll give you your money back. Under the UCC, you have this statutory right, law of the state of Oklahoma and many other states, that you can actually take these and maybe sell them for scrap or dispose of them otherwise, okay? And then you keep the profits from whatever you sell. Then think about it, your damages are reduced by whatever you got from that crappy stuff that I sent you. So instead of $100,000, I might only owe you $90,000 because you got 10 grand as scrap parts. Now to do that, you've got to give me notice, or I've got to give you notice, depending on who has it. I have to give the other one notice, oh, we're going to sell it off. Let's see. I'll let you read that. Repudiation, same thing. Now, here's an interesting question. I still have the stuff. You were going to pay me $100,000 for these computer parts. What are my damages? Well, the court's probably going to look and can look at a bunch of different factors, but probably the most common is, what were my lost profits? So in other words, I've already paid everything for my workers and parts and everything, and for this $100,000 worth of goods that I sold you, I might have only made $20,000 in profits. So, you have to look at, what are the profits? What's the percent that was owed? What have they really lost? So I don't want to get too deep in the weeds in that, but these are some of there are different rules that a judge or jury can look into on how much you recover. Okay, Goods in transit, let's not, I don't think there's any chance we'll test on anything like that, so I'll let you read through that. Let me keep going. All right, because again, I want to focus on goods right now. I gave you non-conforming goods, just like I talked about. I gave you crap instead of good computer parts. You can reject all of them or any commercial unit. You can obtain cover. Really interesting. So you've got to get these computers out of the door. It takes me 6 months to make the parts. Well, 3 months, but you've got to sell them in 2 months. Well, you've paid me $100,000. You were going to pay me $100,000 for it, but you didn't, because when you got them, they were crap. You don't trust me anymore. Theoretically, you could cover, like, oh my gosh, I've got to get computer parts because I've got sales coming up in 2 months. So you might go to Taiwan, and if you get a lower amount, you actually save money. So theoretically, you don't have damages. But if you had to go to Taiwan and say, I have to have these in 30 days, they're probably going to charge you an expediting fee. So if you haven't paid me the $100,000, okay, then, but you have to pay $110,000 to another supplier, you're not really out $110,000, you're out $10,000, as long as they give you those computer parts. So what do you sue me for? The $10,000 extra you had to pay somebody else to give you those parts. That's this concept of cover. I got damaged by 10 grand because I had to pay expediting fees to get parts from somebody else. You can reject it. We went over that. Let's keep going. I think we've covered almost everything. In your written contract, keep in mind you can agree that the Uniform Commercial Code does not apply to certain things, or a judge could say this remedy that you, the buyer, has is in addition to all the remedies you could have under the Uniform Commercial Code. So we might agree that we can give you even more. Now, this is going to look like what you saw under common law offer acceptance contract. What are consequential damages under the Uniform Commercial Code? Well, you know, you had to pay someone else. You had to pay this. Well, some big companies will say, look, we're going to just say X is a reasonable amount for your damages. Or we can say you can only get, 110%. Or you can actually sometimes, as long as it's not unconscionable, unreasonable, you can agree what the damages would be if there's a dispute. So sometimes that happens. Statute of limitations, we already talked about that when it was in one of the videos. How long do you have to sue somebody about a contract for the sale of goods? 4 years under the Uniform Commercial Code. And that ends the amount of time you have to listen to me on this lecture. I wish you well, and I will see you again next lecture.